Good evening, everyone, and welcome to this webinar by MMAC C.A.R.E, Cumulative Aid for Resident Elders, on the subject of wills and power of attorney to protect your family and properties. This session being conducted as a part of New Horizon Senior Program Grant provided by Government of Canada. Firstly, I would like to thank Government of Canada for availing the opportunity and funding to conduct this event for our community. MMAC stands for Malayali Muslim Association of Canada, and our goal is to cater to the needs of the Malayali Muslims residing in Canada. We hope to bring the community together through seasonal events, social service initiatives, and educational awareness programs. This event emphasizes why it is so important to draft will and power of attorney now, and how do we do one in place. So for the same, I would like to welcome our speaker, Mr. Shahzad Siddiqui, who is practicing in the areas of Islamic finance, wills and estates, complex commercials, tort, and estate litigation. He's an undergraduate degree from University of Toronto, an LLB from Osgoode Hall Law School, and LLM from the University of Pennsylvania Law School. He is the author of previous texts entitled Islamic Wills, Trusts, and Estates, Planning for This World and the Next. He also presented at Harvard Law School on Abrahamic finances and has argued in 2 religious freedom cases at the Supreme Court of Canada. At the Law Society of Upper Canada, he has presented the Sharia administration of an estate and published works on Sharia-compliant private equity. Today, he'll shed light on the full process of drafting a will and power of attorney. So before we start to the structure of the event, I would like to tell, after the presentation, there will be a question answer session for the queries that has been submitted prior to this event. For any additional queries during the presentation, I would like to direct you to the comment box, for which, if the time permits, it will be answered by our respected speaker. For those of you stick with us till the end, there is an offer you won't regret. So for proceeding to the main event, I would like to welcome Mr. Shahzad Siddiqui for his presentation. Okay, sir, I'll hand over to you.
Thank you very much. Assalamu alaikum, everyone. It's an honor to be presenting at the Malayali Muslim Association of Canada. This is my first appearance before the association, and this is in fact the first Zoom seminar I'm doing out of home. I guess these are the times that we live in. I'm happy to see people engaging on a weekend on a topic of such importance in terms of the sacred law that we adhere to and the secular requirements. In one way, this is where divine guidance meets earthly limitations. And I'm going to go through some of the divine guidance there is for us in this important area of protecting ourselves and our families in this world and the next, and then some of the earthly limitations that are present because of where we live and the environment in which we live. So I'd like to begin the presentation with just some Quran and hadith. Wal asr innal insana lafi khusr illa allazina amanu wa amilus salihati wa tawasaw bil haqq wa tawasaw bis sabr. Indeed, man is in a state of loss, and we will get into how one could shore up the loss both for oneself and one family in writing these very important documents that I'll get into today. So the first hadith I'd like to share with you is the one where the Prophet is describing estate division, and he says, learn estate division, because this is knowledge that will be taken from you, and I will be taken from you, and there'll come a day where 2 men shall dispute about the obligatory share, and there will be no one to judge between them. He also said, peace be upon him, that no Muslim should go more than 3 days if they have assets to bequeath without having their will ready with them. And in one narration, it is to have the will ready with them under their pillow. I don't go that far. I have the will with me in my bedside table. But those hadith indicate the importance of this area and our engagement with it. I do have a brief presentation that I will share. And I wanted to begin with a photograph that was taken some time ago. This is of Albert Einstein's office on the day that he passed away. And there was a very intelligent photographer from Life magazine who, instead of going to the funeral and the burial of the great man, ended up going to the Princeton Institute of Advanced Studies and into Albert Einstein's office, and took this iconic photograph that then found its way into Life magazine. So I begin with this photograph because I want people to think about the legacy that they'll leave behind in terms of drafting their will, perhaps their living will and their power of attorney documents, a family trust, a gift agreement, and all sorts of other documents that they could make provision for within their lifetime. So as we go through the various sections, I'd like you to think about this, and perhaps we can also address it in your questions to me after the session. So the agenda for today is relatively straightforward. We begin with the important question of what is a will. Then we get into what happens if somebody passes away without a will. That's known as intestacy. We get into why someone would even need a will if there is legislation in place that deals with an estate. We'll get into what is an estate, and then we'll end off with the structure of a conventional will, and then get into an Islamic will. So the first question, and obviously an important one, is what is a will? In our Islamic tradition, somebody could give an oral testification, and if there were two witnesses present who knew what that testification was, then they could convey that to the people. That doesn't work in Ontario. A will has to be written in Ontario. And a will is a document that only becomes active when somebody becomes inactive, and that differs then from what you have with powers of attorney. So a power of attorney for personal care, for example, is an important document that deals with medical decisions if somebody's not able to make them for themselves, if they're incapable in that particular circumstance because somebody has dementia or Alzheimer's or Parkinson's disease or other cognitive issues. Tends to be more for dementia and a coma type situation where somebody's not able to make decisions for themselves. Then there's also a power of attorney for property, and this could be a limited power of attorney, or it could be a general continuing power of attorney. Limited one would be for a specific purpose, such as the purchase and sale or renting of property that somebody owns here, and they're going overseas and they need to appoint somebody to attend to the legal documents for that purchase, sale, or rental of property. It could also be to handle a court case while somebody was away, or things of that limited nature. A general continuing power of attorney would be for more expansive categories, dealing with not only property, but court cases, bank accounts, and all manner of nature of stocks and investments. So that can be quite a comprehensive and powerful document. And it's usually advisable that that powerful document only go into effect when somebody is incapacitated, as opposed to immediately, because of the powers it conveys on what they call the donee, or the receiver of the power of attorney. So the will is a different document, and it only takes into effect upon somebody's passing into the next life. And there tends to be three very important things that you set out in the will. One is who you appoint as the executor or the estate trustee. otherwise known as the trustee. And that is the financial caretaker, the person who will essentially gather all of the financial assets and distribute them to the beneficiaries. Obviously, it's a person that should be well trusted and should have some financial literacy. Then the will generally deals with another very important person, which is the guardian and custodian of minor children. So that would be the caretaker. And so that could be somebody very different, more of a nurturing type personality, rather than somebody who's got financial management skills. And so very often they are one and the same person, but they could be two different people as well. And then very important, of course, is how the assets are to be distributed in the will. And so interestingly, when I get will checklists, this is the part of the checklist that's often left blank, when it tends to be obviously one of the most important things in the checklist. So often bears thinking about, often has to be discussed with a lawyer as to how that's going to be structured, depending on how the assets are already structured. And I'll get to that in a moment. This is an interesting New Yorker cartoon where there's obviously a wealthy gentleman who says, "Now read me the part again where I disinherit everybody." And as we know, in the Islamic tradition, you cannot disinherit everybody. There are what they call fara'id, or primary heirs, such as your spouse, your children, and your parents. And in fact, if somebody goes into a terminal illness or is on their deathbed, they're not allowed to divorce a spouse so that they can disinherit them. That is forbidden under Islamic principles. So before we get into the actual the will discussion about people's own preferences within the Islamic context and the Ontario one, I wanted to indicate what kind of freedoms people have within their will. And this is a gentleman by the name of Charles Vance Miller. He was a lawyer, he was a silver owner, and he became a wealthy man at the end of his life, and he had no beneficiaries. So he did some interesting things with his will. He, for example, gave brewery stock to 3 temperance advocates. So people who didn't believe in drinking, he gave them stock in a beer company, essentially. He gave his Jamaican vacation home. If you look at the top of this will, it's very small writing for you, but I'll just read out here. He gave his Jamaican vacation home to 3 sworn enemies of each other. This was the provision that he wrote in his will. "I give for life my home on Jamaica Island, known as Ivy Green, on the half-made tree road. And upon the death of the last survivor of them, I direct my executors and trustees to sell the same and give the proceeds to the Council of the City of Kingston, Jamaica, for distribution among the poor of that city deserving help." The most controversial bequest that he gave in this will is he set up a competition. So within 10 years of his passing, the woman in Toronto with the largest number of children would get the bulk of his estate, $500,000, which was a considerable amount of money at that time. And so the Ontario government took this will, took issue with this will, and took the estate to court on the basis that you couldn't have a will that encouraged overproduction of children. That went to the Ontario Court of Appeal and then went to the Supreme Court of Canada. And the Supreme Court sided with the estate and said there is testamentary freedom in Canada. And even though the Ontario government might not like this competition, certainly it's within the rights of the testator, Charles Vance Miller, to produce a will like this and to have a contest like this. There were 2 books written about this case, and there was a movie made called The Stork Derby. And I believe there were 4 women tied with 10 children each who ended up winning the contest. So then, if someone like Charles Vance Miller had not written a will, what would have happened to his estate? So there's a common perception, I think, driven primarily by attorneys in America, that if you don't have a will, the government takes it all. That's certainly not the case. There is an estate plan that's set out in the Succession Law Reform Act of Ontario. And in that, the preferential share goes to the spouse. So the first $350,000 now goes to the spouse. It used to be $200,000, but I think given the nature of the real estate market, the government decided to increase it to $350,000, and then the rest gets divided between spouse and children, depending on how many children you have. If you don't have a spouse or children, then it goes to parents. If you don't have spouse, children, or parents, then it goes to siblings. And so that obviously didn't happen in Mr. Miller's case because he had no direct relatives. Now, if you don't have immediate relatives that are immediately accessible, then perhaps the government will look far and wide to actually find potential heirs. And this is a chart that they would look into, and it can obviously get quite extensive. If you've got heirs that are overseas, it's obviously difficult for the government to track those people down, especially in an age where there's no letter mail and everything tends to be by way of email. So indeed, the government will look, but they may not find. So that's something obviously to keep in mind. Now, if there is this scheme under the Succession Law Reform Act, then the question arises as to why one needs a will at all. Of course, the first answer for people of religious persuasion and otherwise is that the government chooses your distribution. It becomes longer and costlier to administer the estate potentially, especially if they're competing claims about who should be the executor or the estate trustee. There can be competing claims about who takes care of the children who are under 18, if somebody wants to be a guardian and custodian over here. So very often people will write a will, not really to even deal with the asset distribution, but to deal with who takes care of the children, because that's what they're more concerned about. And then, of course, there's no estate planning that one can do. This becomes important, for example, with people who have a private business. I'd like to share with you the story of Philip Granovsky, who was an entrepreneur. He created this company called Atlantic Packaging Company. You may have seen the trucks around the city of Toronto and in the Greater Toronto area. Became a large company. At the end of his life, it was worth about $25 million. And by doing a dual will, and I'll show you mine because I have a professional corporation. So I have a primary will here, and then I have a secondary will. And the secondary will is to deal with the shares of the private corporation to save them from probate taxes. And so anybody who runs a private business, even if it's a startup, may want to consider doing a private will so they shelter the shares of the private corporation from unnecessary taxes. Now, the question also becomes, what is in an estate? And this is especially important between spouses. So, for example, if there's real estate, it may be under joint tenancy. So that's going to go to the survivor, regardless of what the will says, because of operation of the law. If it's a joint tenant property, it'll go to the survivor of that property. If it's tenants in common, however, then it will go according to the percentages. So if it's 50-50, for example, 50% will go according to the person's will who passed away, and 50% will be retained by the other owner. With a bank account, there's a similar setup. It might pass by rights of survivorship to the surviving person. This can become controversial if there's children who are on a bank account, but they're only there for convenience purposes. So there's a famous Supreme Court of Canada case called Pecor versus Pecor, which said that there's a presumption of resulting trust, a rebuttable presumption of resulting trust, meaning that the law is going to deem that that child is holding the account in trust for the other beneficiaries, unless that child can show, no, I'm the actual owner of this account. So in order to avoid that kind of controversy, it's a good idea to write into your will what that account is if it is shared with a child. If it's shared with a spouse, generally you'll go directly to the other spouse by rights of survivorship, but it depends on how you set it up at the bank. RSPs and life insurance, they will fall into an estate only if there's no beneficiary designated, or the beneficiaries pass away, or the beneficiary is the estate. And this becomes important because it's a good idea to have a beneficiary of an RRSP and a life insurance if you're getting that through work, for example, because then it'll go directly to the beneficiary. If it's life insurance, it won't attract any taxes. If it's RRSPs, you can't really avoid the taxes, but you will save some of the probate taxes by having a beneficiary designated. And so these are some of the other items that are potentially in an estate. Of course, we know there's cash. With cash, it generally will not be taxable if the tax has already been paid on that. With bank accounts, similarly, there'll be no taxes if taxes have already been paid on the money in the account. With respect to a house, the principal residence is exempt from taxes except what they call probate tax. So if this is held individually by one person, then that house will fall into the estate and be subject to probate tax, but that's the only tax on a principal residence. On an investment property, there is capital gains taxes that are payable. So keep that in mind. There's a special place for a principal residence. RSPs, I mentioned already, no taxes have been paid on them, so there will be taxes. That's what they call a deemed disposition. RESPs, they will fall into the estate unless there's special provision made for them in the will, because those belong to the subscriber. So those belong to the person who made up the RESP and not the beneficiaries necessarily. TFSA as well, that will go to a beneficiary if one is designated, and generally there is one in those tax-free saving accounts. Life insurance I've spoken about, again, it tends to be tax-free unless it goes into the estate where it'll attract probate taxes, but not any other kinds of taxes. There are accident benefits sometimes that arise if there's a car accident, for example, that caused a fatality, and what they call a tort action, which is a lawsuit that would be an asset of the estate. Jewelry, very often there's already provision made for that in one's lifetime. Everybody sometimes knows what they're supposed to be receiving, but it's obviously if there's a lot of jewelry and it's valuable, it's a good idea to make provision for that in the will. Sometimes you can make a special bequest, like a car that you wanted to give to somebody, or a stamp collection. And then in this day and age, there are digital assets as well, not only Bitcoin, but there are social media accounts that sometimes can be very valuable if you're getting a million hits and things of that nature. So before I get into the other will, I'd like to describe generally what are the requirements for a will in Ontario. So obviously you need your name, you need to appoint the executor, or the estate trustee that I've already mentioned. You need to mention the guardian of the children, if you have children under the age of 18. For both the executor and the guardian, it's a good idea to put a substitute. Generally, the first person chosen is going to be the spouse. And then there would be a substitute, which would be obviously a close family member or a friend, or even a child, if they're of age. And then there's the asset distribution section. There's a signature that obviously has to be on the will. And then generally speaking, there is free rein to do what you wish within these parameters, as I set out in the will for Charles Vance Miller. There is also what they call a holographic will, which is a will that you do in your own handwriting and you sign. And so this will arose out of very tragic circumstances with a gentleman called Cecil Geo Harris, who was a farmer in Saskatchewan. He got stuck under his tractor while he was mowing the fields. And even in that very difficult circumstance, he had the presence of mind to take out his pocket knife and write on the casing of the tire, in case I die in this mess, I leave all to the wife. And so this writing that he had done on the casing was taken to a Saskatchewan court, and this will was probated as a valid will, a valid holographic will. Generally, people will not recommend you do these unless it's very trying circumstances, because it's easy to challenge them, and they tend to be done in quite rushed circumstances. So you have to prove it's the writing of the testator. You have to prove that there was no undue influence when the testator was writing the holographic will, because obviously it's not done in an office of a lawyer or a notary public. And so special precautions have to be made. Now, with respect to the Islamic wills, then there is freedom within Ontario, as mentioned, but it comes with certain strictures. And one of those is the Ontario Family Law Act, which says upon death, half of all net family property should go to the spouse. So net family property is property that both spouses earned after the marriage, with exception of the matrimonial home, which even if it was purchased before the marriage, goes into net family property. So it's the matrimonial home, regardless of whether it was purchased before the marriage, plus all the other assets earned during the marriage, the spouse would be entitled to half of that. So in an Islamic distribution, a husband who receives a half if there's no children may be okay, but if there are children, he gets a quarter. The wife, she gets a quarter if there are no children, but if there are children, she gets an eighth. Parents would get 1/6 each, and then the sons would get double the share of the daughters. So that tends to be the typical distribution. So there may be a problem there if a spouse is only getting a 1/8 share. Now, in the vast majority of cases, that doesn't apply because the spouse is a joint tenant on the property, and often they're joint bank accounts, and she's a beneficiary under the RSP. And if there's life insurance at work, she'll also receive that. So generally speaking, this doesn't apply, but for people who are maintaining their properties separately, one has to bear this in mind. So you could sign a mutual wills agreement. One of the recommendations has been that you use the wasiya, which is the 1/3 of the will, because under an Islamic distribution, 2/3 is already spoken for by God, and you have discretion over 1/3. So people have said, well, yeah, you could use the 1/3 discretionary amount to top up the share of a spouse. So that's a controversial use of that, the bequest, as they call it, the wasiya. And so that's something that you'd want to discuss with your religious scholar and decide whether you're comfortable with it. Obviously, there's no restriction in Ontario law over using the 1/3 amount. The general use of that 1/3 is for charity, for giving to the poor, for setting up an endowment, or for giving to somebody who otherwise wouldn't inherit. So that could be a non-Muslim spouse or an adopted child. Zayd ibn Harith did not inherit for the Prophet, peace be upon him. So provision could be made in the will for an adopted child. And then you could use it to top up the share of the other beneficiaries, but as I said, that's controversial and will usually require the consent of the other beneficiaries whose share is being reduced. And so that consent, according to the most traditional principles, is one that can only be given. The consent can only be given upon death, and if it's given beforehand, it could be revoked. Ontario courts are wary of getting into religious issues. Initially, they would not enforce the mahar that was given at the time of marriage. There's a case called Kadura versus Hamoud that said, well, this is a religious obligation, so we're not going to enforce it in a Canadian court. And then there were subsequent cases. There was one out in British Columbia called Nathu versus Nathu that said, well, it's a contract like any other contract. It may have religious connotations in it, but at the end of the day, it's a contract that we may be able to enforce. And so Meher is now well entrenched in Ontario law, but it gives you an indication that the courts may not be comfortable simply enforcing a will that says distribution is to be made according to Quran and Sunnah. It's important to put those details, the fractions, in the actual will, or incorporate by reference a book that has the fractions in it, or appoint an executor that has that kind of knowledge, although that one I wouldn't probably recommend. We've probated wills. We've got wills that have been probated through the courts that have simply said, I want my distribution done according to Quran and Sunnah. And so somebody's in a situation where they have to do a holographic will because they have never made it into a lawyer's office to actually do a will, then it might be possible to do it in that manner. The other items that go into a will are a preamble or precatory words. These are fervent wishes that somebody might have. And I'll read some samples to you in a moment. There could be directions about funeral and burial rights. I own 2 plots at the Toronto Muslim Cemetery Corporation, who's a client of mine, and they were gracious enough to organize this. So if you're going to put provisions in the will about funeral burial and you have a plot, then it's probably a good idea to flag that in the will itself, and to keep these kinds of documents with the will. Special bequests are bequests over to charity, and under Islamic principles, that's generally held to 1/3, because the Prophet, peace be upon him, said that you should give a maximum 1/3, and even 1/3 is a lot, on the basis that you should leave something for your family and not leave them destitute. Now, there are also provisions you can make regarding debts, taxes, and other expenses, including funeral and burial expenses that you may want to put in the will. Very often, if there's a private debt that you want to get paid out, that's good to put in the will, obviously. If there's an amanat that you're holding for somebody else, that's obviously a good thing to put into the will. And I promised I'd read you some sections of what people have put for their preamble. And I'm just going to read some samples here from wills that have come through us. So it says here, my family and friends have been a source of strength and happiness throughout my life, and I request them to honor this by keeping close ties with each other and the relatives and friends of their parents, and ensure that their children do it as well. I request all of my immediate relatives and closest friends, for the sake of Allah and out of fear of Him, to settle their disputes and correct their relationships among themselves according to the following orders of Allah in the Holy Quran. So fear Allah and amend that which is between you, and obey Allah and His Messenger, if you should be believers. I remind them that no person dies before their time. The exact duration of each lifespan is precisely determined before we are born by the all-powerful Creator, may He be exalted. Death is tragic only for those who lived out their lives in self-deception, without submitting to the Creator and preparing for the final return to Him. So do not preoccupy yourself with my death, but instead make the proper preparations for your own. Another sample here, and let those executors and guardians fear injustice as if they themselves had left weak offspring behind and feared for them. So let them fear Allah and speak words of appropriate kindness. Indeed, those who devour the property of orphans unjustly are only consuming fire into the bellies. And as the Quran warns, they will be burned in the blaze of hellfire. My final bequest for my family and children is the same one that the Messenger of Allah, peace be upon him, enjoined upon his followers, the prayer. I advise and implore my family to have patience and accept Allah's will. This concludes my final will and testament. I am now free in front of Allah from any words or deeds that distort and contradict this document according to the guidance of Allah's Messenger, as forewarned by the Quranic verse, then whoever alters it after he has heard it, the sin is only upon those who have altered it. Exalted is your Lord, the Lord of might, above what they describe, and peace be upon the messengers, and praise to Allah, Lord of the worlds. And then I've had people who've done the Sufi type of will and asked the fellowship to organize a celebration of their life as opposed to a funeral, and so they put provisions like that in their will. If there's people interested in a deeper dive, just reading from sections of the wills book here, and this is my contact information for anybody who's interested following the presentation. And inshallah, that concludes my presentation for you this afternoon.
Thank you, Mr. Shahzad Siddiqui, for the very detailed and informative session. Before we meet to the QA section, due to technical difficulties, I could not connect to Ibrahim Kurikal before. So I would like to invite Mr. Ibrahim Kurikal, one of our senior members in our community, to share his thoughts on this event. Yes, sir.
Assalamu alaikum. Thanks, Shiaz. I think the line is correct now. Thank you for you and MMAC having in this session about the will and things to me here. Most of the things Mr. Siddiq said to you guys, and that is the thing is going on. And I don't have more than an experience to say to more than Siddiqui said. He said most of the things. What is my experience, when we came in Canada a long time, we don't have that kind of understanding or knowledge about what he said now. It's all totally new for me. And don't do like that. And do everybody what he said. That's what I have to address to you guys. In experience, we don't have to wait until we die or until our death to make a power of attorney or the wills. We do before that. That's what I have to say to you guys. The other thing, this is a good thing, MMAC bring it in front of us. This chance subject to come into their awareness and take steps to everyone to implement in their life. In India or anywhere in the back home, and here in Canada, totally different what we have experienced in India or whatever back home. It is totally different here. So we should understand that we have to experience these things. And most of the things is Mr. Siddiqui told us, and we heard about that. I think we will practice that. And my request to you guys or everyone to go for that. That's the important thing for us. And thank you guys. Thank you.
Thank you, Mr. Ibrahim Kurikal, for your words of wisdom. So, Mr. Shahzad, can we start with the questions? We have received some questions prior to our program. So I'll start with those. And also we have some questions in the comment box. So if time permits, we'll add those questions also to our list. Is that fine? Okay.
Sure.
So I'll start with the first one. So we have a question. Can I write a will on paper myself if it's not complex, or is it compulsory to have a lawyer?
No, it's not compulsory to have a lawyer. You can do what they call a holographic will. And I'd shown a holographic will during the presentation. I take it if that's the first question that person saw the holographic will, which was on the tractor tire. So that was obviously done in very trying circumstances, and may God save us from an end like that. But you are able to do a will in your own handwriting. It must all be in your own handwriting and signed. It's when you do a typewritten will, then there must be two witnesses. And then one of the two witnesses has to appear before a lawyer or a notary public. So even in that circumstance, you don't necessarily need a lawyer. You could do a will where you type it out, but the requirement for a lawyer is where you have to get the will with an affidavit of execution, they call it. The witness has to sign an affidavit of execution that they were present at the same time when the testator signed, and they were in the presence of the other witness when the testator signed. I'm involved in a very drawn out court battle. I mean, it's probably now been about 4 years, and there's, well in excess of $50,000 that have been spent in legal fees because there wasn't proper execution. So if you're going to do the typewritten will, then the advice is to obviously do it properly.
So otherwise you have to write your will in your own handwriting.
And sign it, yeah.
And for the next question, can we include the ancestral property from our home country in the preparation of the will here? Is it possible?
It is possible with respect to what they call immovable assets, which are things like land and other property. Very often the jurisdiction will not allow foreign law to apply. So, if you're in a Muslim majority country that stipulates it has to be according to Sharia distribution, then it doesn't really matter what the Canadian will says about those ancestral lands. They would go according to the local law, unless the local law permitted a will to override that. So I think the best advice there would be to consult a local lawyer where the ancestral lands are to see if the Canadian will would apply to that.
So you have to consult that. Okay. So the next one, there is an inquiry about Sharia and will. The question is, can we write a will in Canada that comply with the Islamic Sharia?
Yes. So this is an interesting question. And I addressed it somewhat in my presentation by saying, if somebody has a half share, let's say a husband there's no children in the marriage, the husband will get half of the estate anyway. That's compliant with Ontario law that says a spouse gets half in any event. And so the way you do it is you use the 1/3 discretionary amount known as the wasiya to top up the spouse's share if they're getting less than 1/2. But that's a controversial use of the bequest. So that's why I'm recommending people not only talk to their lawyer, but also their religious advisor in terms of Sharia compliance of an Ontario will.
So for the next, a person has a will, but close to the time of death, if he make any changes verbally, with or without witness. So with and without witness will be different scenario. So how would that play out?
Unless it's done in writing, it's not going to override the existing will.
So even with the witness, it should be under writing.
Yes, it should be in writing. And the previous will would then automatically be revoked unless somebody in that circumstance did not have capacity to change a will, if they didn't have mental capacity, according to their doctor and other capacity assessors.
Okay. So who all should have the knowledge of the will that be prepared?
Most important person is the executor. They should actually know where the will is physically being kept. They don't have to know the contents of the will, but they should know where the will is kept. Some lawyers will have a vault where they'll keep the will with them in the office basement. Most lawyers will give the original back to the client because there's no requirement that if a lawyer does your will that the family has to go back to them to execute that will. So most lawyers will give original copies back to the clients. I'd recommend that you not keep it under your pillow, but you keep it in your bedside table, or you keep it in an area where you have important documents like your passport and things of that nature.
So it's not necessary for, also everybody should have the copy, or only client should have the copy? of the will?
The client should have the original, and then they should let the executors know where that original is being kept.
Okay.
And if they want to give copies, they can. I mean, there's no prohibition on it. So they can give copies, but it's only the original will that tends to be valid. That's the document that has to be probated. And there are ways of getting a copy. You can prove a copy to be a will by solemn form, but the original will is important.
So I will go through some of the questions that we got through in the chat. What about the liabilities of the deceased? Would the liabilities will be passed to the inheritor?
No, those liabilities would stay with the estate. So classic example is a house with a mortgage on it. That mortgage would not pass to the inheritors unless there was an assumption of the mortgage after the fact. And if nobody assumed it, then the mortgage would have to get paid out. The equity would then be distributed to the beneficiaries. But there's no liabilities, tax or otherwise. In fact, in Canada, there's no inheritance tax to the beneficiaries, unlike America, where inheritance is taxed. All of that happens at the estate level before it goes to the beneficiaries.
We had one question regarding the tax. You already answered that for us. And they have another question. Is it advisable that both partners, husband and wife, to have two separate wills, or together it's enough?
I would recommend that there are two separate wills. If, God forbid, something happens to one of the spouses, then it becomes impossible to change a will after a spouse passes away. And there might be life circumstances that require it, such as a child in greater need of the other children, or things of that nature. You know, for example, if there's a disabled child and they need access to a certain asset. So I've never done a joint will. I know lawyers that have done it, but I wouldn't recommend it.
You prefer to have separate wills for husband and wife?
Yes.
Can we appoint a person who can execute our will?
Yes. So that's one of the three most important things that you have to put in the will, is who's going to execute it. That person is known as the executor, executrix if it's a woman, or a state trustee, or simply a trustee. So that is generally, without appointing an executor, it becomes difficult to implement the will.
Is the executor should be the same as the beneficiary, or it can be from outside?
An executor can be a beneficiary, and the only prohibition really is on that person signing as a witness on the will. So very often it's the spouse that's the executor, who obviously would be a beneficiary, and then it's a child who would also be a beneficiary. That tends to be the most common way people set up the will. And so both of those people are beneficiaries. So there's no prohibition on that.
No prohibition. So what if a designated irrevocable beneficiary and the beneficiary dies before the client? What will happen to the will?
If there's an irrevocable beneficiary, yes?
Yes. And if the beneficiary dies before him?
Then it'll go generally to the other beneficiaries. Now, if there's no other beneficiary, then it'll go to the government. That's called a sheet to the crown.
Okay.
And so that becomes important for people with small families. I think Her Majesty probably has enough. So you probably want to donate it to a charity or some other institution if your family is not going to get it. And there are ways you can set up the will. So, for example, if you have 3 children as beneficiaries and God forbid one of them passes away, that their children will inherit their share. That's called per stirpes. I think in the Islamic tradition, you're supposed to inherit from your own parent, but that is an option under a will to make it per stirpes. So if a 1/3 share, let's say, that's supposed to go to a child, instead of going to that child, it would go to their children. if something, God forbid, happens to them.
Thank you, Mr. Shahzad. You answered all the questions that I have had with me.
Okay.
Okay. So I hope everyone had a good information on preparing will and power of attorney. We had a participation of around 300 people in YouTube live and around 30 in the Zoom on this beautiful Saturday evening. As a special announcement I have mentioned earlier, Mr. Shahzad Siddiqui is providing the service for preparing will and power of attorney at a special rate of $250 for those claiming through the MMAC contact. And moreover, MMAC in association with Government of Canada is pleased to offer a $75 discount on cost for the first 10 senior resident applicants. So for claiming these offers, please visit our MMAC website for more details. As to conclude, I would like to thank MMAC for bestowing this honoring for hosting this enlightening webinar. On behalf of all, I would like to thank Mr. Siddiqui for facilitating this session for our community. I would like to extend my undying gratitude to the MMAC C.A.R.E, who have been very diligent behind the scenes to make this event happen. Once again, thanking you all for the participation and have a good day.